It's May 12th of 2026, and this is the Court Gallery. Welcome back, ladies and gentlemen. Today we've got a masterclass in what not to do when facing the court. First, a defendant on Judge McNally's sobriety court with 4 prior offenses thinks picking up shifts at a local bar is a solid career move. Then, Judge Stevens deals with a supposedly bedridden man who's too sick for jail, but finds the strength to sneak out of his care facility for some Colombian marching powder. Finally, a chaotic child custody case involves a dormant bearded dragon, terrible housing conditions, and a neighbor wielding weapons at police. These true stories are stranger than fiction, and it all starts right now.
Summer Lori Greathouse, 25F245336. Morning. All right. Your appearance, please, Mr. Lori. Name your name. All right. So your client pled guilty to operating while visibly impaired back on March the 3rd of 26. She was referred for screening and assessment. At some point prior thereto, she violated the bond conditions on February 12th of 26. I issued a bench warrant, forfeited the bond, and set a new bond after finding that she had consumed alcohol. I told her at one point that she'd better get into sobriety court. If she did, I wasn't guaranteeing any new, I wasn't guaranteeing anything, but that I guaranteed she was going to go to jail for a lengthy period of time if she didn't get into sobriety court. And that's where we are. If you had a chance to review the report, any material additions, corrections, or deletions.
Oh, yeah.
Anything that you would like to say on her behalf?
Your Honor, when you filed the pickup, you thought there was you have time about plan for sobriety. She had to determine anything that she lied. And she is no longer in denial. She has a alcohol substance abuse problem. In work, she's working hard as a broker. She has 3 small gifts. Apply with probation officers and minor flips. She didn't fire me large.
Okay, anything else? Ma'am, anything you would like to say?
I am taking this seriously. I have been going to therapy on my own. I've been seeing a therapist now bi-weekly. I am going to IOP. I take that very seriously. My kids are my why. I am committed to this program. You would accept me.
John Cohen there.
Okay.
You had a job interview at DTE, but you haven't heard anything yet? And you're working at LPT Realty, and that's the only place you're working.
I'm sorry.
That's the only place you're working?
I have helped out a friend. She just opened up a restaurant. I helped her a couple of times, but outside of that, no.
What restaurant?
JT's in Trenton.
Why didn't you tell your probation officer that before?
I'm sorry.
Why didn't you tell your probation officer that before? And why did I have to ask questions to find out that you were working at JT's?
I just helped them out a couple of times. I'm not like fully employed there. I want to be.
Okay, hold on.
I'm not able to do real estate full time right now.
Why didn't you tell me that?
Sorry.
Why didn't you tell me that? You got 4 drunk drivings. You have no business working in a bar. And I don't mind telling you if I had known in your situation, now I want you to understand, I've allowed people to work in bars and restaurants before that are in sobriety court, but these are under different circumstances. You had 4 drunk drivings. You had a 271. You violated your bond conditions. You've been working at JT's a lot more than a couple times. Don't tell me that. That is not truthful. I know too many people, young lady. I know too many people.
I
I know too many people. Don't tell me you've only worked there twice. You said a couple times you helped out a friend and you didn't bother telling anybody your name. So I want to know, because you and I talked, because you had a conversation with her. I want to know, I want you to state for the record what she told you. And tell me when it was.
So the appointment was on April 20th. Found out the meeting with you on April 20th. That she was working at the bar. So at our appointment on Friday, that's saying April 24th. We had just been going over the screening. I asked if there were, anything new to add. We talked about employment and how she is supporting herself due to backing on real estate, and she said that she was supporting herself with her savings.
She didn't say anything about working at JT's.
Your Honor, can I tell you what?
Yeah, you can tell me whatever you'd like, and I'd make it really good. I cannot have people in a sobriety court that are not being upfront and truthful with me. I can't do it. I won't do it. It's not, you have no chance. You had no business taking a position at a bar, serving as a bartender and a waitress. None. Particularly without coming to me and asking me if that was okay, or at least bringing it up with your probation officer, and you concealed it.
I didn't conceal it on purpose.
On
I
purpose.
thought if I opened the place and asked her if I could pick up some shifts there to supplement my income because I'm not able to do real estate full time right now. I'm not full-time employed. I would like to be. I really need the money to support my kids right now. I know the people that work there and I'm able to get rides from them. So yes, I have picked up shifts there. And I stopped asking to bartend. I was only picking up the serving shifts.
Listen. I have to go by my gut. I don't sense that you're taking this serious. You violated the bond conditions. You had 26 late blows. You tested positive on February 8, 9, 10, and 11 for alcohol. Like I said, you missed 26 blows or they were late. You're not getting your AA logs to her in time. Listen. When I do this, I'm putting myself out there. Okay. When I try to help people in felonies and this should have been a felony, like I told you, somebody dropped the ball in my view. I don't know why they didn't charge this as a felony. You got 4 of them. Grant, it goes back to 09, but you're only 38. You're only 38 years old. And you needed to cross every T and dot every I, and you didn't.
I have 3 children that I'm trying to raise.
You're going to kill somebody. You're going to kill somebody. And I can't do this. I wish I could. The whole team agrees you need help. Ma'am, I can't take you. I cannot take you. Can't do it. I wish I could. I get so disappointed listening to people when I know that they're lying to me. This is not voluntary truthfulness on sobriety court in particular. There's no way I'm changing my mind, Mr. Longton.
Well, Your Honor, she was desperate because the family law case, he received no child support and had overseen the child support until they need you. If you've been desperate to get forward, so all of us usually she asked for a surgeon to get solved.
Okay, 3 kids, I'm gonna take care of myself.
I get it. I get it.
I have been
And you-
very
and you-
committed to myself and to therapy.
You also, listen, I want to take you. I want to take you. No. I cannot. I agree you need help. I cannot do this. Ma'am, you should have thought about that before you got your first, second, third, and fourth drunk drives. They should have charged a felony. You had a chance to keep this to a 93-day misdemeanor with a minimum jail term, and you were not truthful, and you went to work in a bar, which I can't even think of a worse place for you to be working. I'm sorry. 300 fines, 600 costs, 75 victims' rights fee, $50 justice assessment, $60 screening fee, $225 in cost of recovery, and 61 days. Credit one, serve 60 now, and you're going to serve 30 more days if you don't pay your fines and costs. And I will let you pay those at the rate of $50 per week. And I will start that beginning on August what's the first Friday in August, Lisa? Amy?
Right, could you possibly do this on the weekend?
No. There's no way I can let her do it on weekends. You have 21 days to appeal. You have 14 days to apply for a board-appointed lawyer. You should have thought about all these.
August 7th, Judge.
This 7th. If you need more time, you call the court. We'll go on Zoom. I feel awful about this, probably as awful as you do, except I'm not the one serving the jail term. You're going to we'll let you make some calls, but you're in custody for 60 days. Yes, you are. And I'm not going to let you start tomorrow because you weren't honest with me. And when people aren't honest with me, this is what's going to happen, particularly with something that's as serious as going out and committing full drunk drivings. You have no idea how lucky you got that they didn't charge you with a felony. I'm sorry, ma'am. Have a seat. That's it. Sorry, guys. Mr. Westmoreland, your name?
Good morning, Judge. Attorney Corey Westmoreland, appearing on behalf of Mr. Little.
It's still muted.
Corey William Little.
Okay, officer, your name?
Sergeant Mitchell with Flat Rock.
I'm sorry, Sergeant. My apologies. Okay, so defendant still owes a substantial sum of money. He was sentenced by Judge Hessen on the misdemeanor back on July 20 of 23. He was sent a letter in May of 24. Amy, could you tell me how much he owes on each of these, please?
He owes $185 on the case ending in 090 and $399 in the case ending in 292.
What is he going to do here, counsel? I mean,
Yes.
he's had multiple opportunities. I hope he's got the money. It's been going on for 3 years. We've given him chance after chance after chance. If anything, we should be fault for being so kind. So what is he going to do here?
Your Honor, Mr. Little does acknowledge that he does owe this money to this honorable court. He is a single father of a 2-year-old.
So is he going to plead guilty or is he going to,
That's correct, Judge. We're prepared
is
to.
that what you want to do, Mr. Little?
Yes, yeah, that's okay, sir.
If you plead guilty to failure to pay $399, you could get 90 days. Do you understand that?
Yes, I have
I
some.
just
I
want
have
to know if
some-
you understand that. Do you understand?
Yes, sir.
And you
Yes.
also, You also, you said 185 on the other one, right? Is that right? Amy?
Yes,
am I getting- why am I
one
getting-
eight,
Why am I getting feedback over there?
it's from Flat Rock's jail, Judge.
Can you tell them to ask them to work on that, please, Sergeant? I mean, I don't like to hear my voice that much.
I will let IT know about it.
If you plead guilty to failure to pay 185, you can get 1 day for every $10 owed. You could get 19 days. You can satisfy that in full by payment, in full by serving the jail term, or in part by payment, and in part by serving the jail term. Do you understand that?
Yes, sir.
All right. Okay. Now, if you plead guilty again, geez, that's driving me crazy. If you paid $85, you'd only owe 100 on the civil infraction. You get $10 credit for each day served. Do you understand that?
Yes, sir.
So you'd only have to serve 10 days. Do you understand that?
Yes, sir.
All right. Now, to the charge that you failed to pay 185 on the civil infraction, how do you plead?
Guilty.
Did you fail to pay?
Yes, sir, I did.
To the charge you failed to pay $3.99 on the drivewall suspend that was revoked, that was reduced to allow an unlicensed driver to drive, how do you plead?
Guilty.
Did you fail to pay on that?
Yes, sir.
Anybody force you to plead guilty or promise you anything to induce you to plead guilty?
No, sir.
Pleas are accepted. You got a big problem here. Judge Hessen was kind with you starting back in November of 23. I was kind with you starting back in July of 23. You hadn't paid. We show cause you. Pled guilty to failure to pay $213. I said you would have paid $30 per week beginning July 23. She's had multiple payment plans set up with you. I told you if you didn't have the money to come talk to me, and here we are 3 years later. I hope you have this money. If you don't, you got a big problem. You have the money?
I have majority.
Mr. Westmoreland, what would you like to say?
Yes, Your Honor. Mr. Little currently living in Monroe. He is gainfully employed working at True Cuts LLC Lawn Care. He does acknowledge that he owes the money. Like I mentioned earlier, he is a single father to a 2-year-old. I would just ask for one last payment plan.
When he says he has a great majority, what is that?
What could you make a payment?
I can pay like 150 at least today.
That's not the great majority. You owe the court $584, and you've had 3 years to pay this, and you've been given multiple opportunities.
I could probably come up at least like $200, $300, $400 today. I just don't know exactly what I have. When I was arrested in Monroe County, I had $150 in my pocket. So I'm just saying what I know I for sure have in my pocket.
When are you going to grow up?
Sir, I'm not making excuses. I'm holding 100% accountability. I know I was supposed to pay the money. Honestly, I just completed Monroe County probation back in May of last year, and I take care of a son by myself. I'm currently homeless, and I've been trying to get back in with that. I just want a place to live. I was staying in a hotel for the last 3 months.
Where do you
and my
work?
son. So I work at True Cuts LLC.
Who takes care of your son when you're at work?
I have my mom. My mom takes care of him, and then I have like family friends watch him here and there. and then I also have to pay them out of my wages of part-time from that. So it just I'm trying my best here, sir. I'm not making excuses for it. I know I'm supposed to pay it, but I'm really trying my absolute best. I'm sorry I could have paid at least $10. I could have paid something. You are right about that. And I apologize. My apologies for that. And yeah, I can pay a few dollars. I have $26 on me in my
I thought you said
in my-
150. I thought you said 150.
No, when I was arrested in Monroe, I had 150, but my girlfriend was there, and that was the money we were using towards our rent for where we were staying at. So she had grabbed it. But
I thought you said you were homeless. I thought you said you were homeless.
I am homeless. I told you I just found a little spot to stay at. I literally just found it, and that literally was our first day.
I'm not letting
that's
you
the money
go
that we were going to
pay
pay. So
$26. Okay,
okay, that's understandable.
Sergeant, let them
I'm just saying
make
that's
some
what I have on
calls.
me. But
Have them bring it to the police station.
Have
them bring it to the police station. John, text my court officer. When he's done that, he has the money there. And I will go out of my way to figure out a way to help him, but he's got to grow up a lot. So you can text John and let him know, and we'll go from there. I told you to come talk to me. I don't understand this. I understand people not having the money. You never gave us the courtesy. You came in front of Judge Heston and apparently gave her a sob story on multiple occasions, and each time she gave you an extension. So that's it. Let us know when he's ready. He's got to have a lot more than $26. No, what's your question, sir?
So say for instance, if someone could come in and pay like the $400 bond that I was supposed to be have, instead of paying that $400 bond, is it a way if they can pay like $300-400 on the ticket itself?
I'm going to help you if you act like an adult.
Yes, sir.
Get them to bring you money, and I will work with you. But you can't do what you're doing here, okay?
Yes. So,
Any questions?
do I just have them bring it to the police station?
Yeah, have them bring it to the police station, or you can have them bring it up to the court. But you're in custody until you can come up with some money, and I will work with you. Okay. Good luck. Okay.
So
let John know
what if
you
someone
would,
can pay my
Sergeant.
bond?
And please do talk to the chief or your IT guy or whoever. Thank you. Mr. Little, how much money did you come up with?
I wasn't able to get a hold of my people because my mom was at work until 5 o'clock. And I don't have a phone charger, so
You got a big problem.
It's only been like 2 or 3 hours, sir.
Here's what I'm doing. I'm setting a $250 cash bond on 23F240292. I'm going to sentence you tomorrow, May the 13th. Amy will do this at 8:30 in the morning, okay? I'll sentence you on these. If you post the bond, show up, I'll work with you, but you got to stop ignoring me. I'm going to sentence you on both of these cases tomorrow at 8:30. Do we understand one another?
Yes, sir. But can I ask you a question?
It depends what it is.
So instead of the $250 bond, what if I have them come up here and pay that on the ticket
Then
itself?
you're going to be released, and you're going to have to show up for sentencing tomorrow, and I'm going to be very reasonable with you, but you're not going to thumb your nose at a court for 4 years, son.
Yeah, I understand that, sir.
I'll be reasonable with you. If they post the $250, I'm going to have them release you, and you're going to show up in person at the 33rd District Court tomorrow at 8:30. If you don't do that, I'm forfeiting your bond. We're going to issue a warrant for your arrest on both cases. Do we understand one another?
Yes, sir.
Stop doing this. This is ridiculous. Amy, I'm incorporating that bond onto this file. And I don't know. That's what we're doing. So we're setting them both for sentencing at 8:30 tomorrow. Now, if you post the 250, you'll be released. But do not make the mistake of not showing up tomorrow at 8:30. Do we understand one another?
Yeah, I'm just gonna probably end up staying here and just have them pay the money towards the bond itself.
If they post the bond, you'll be released. They don't need you there. You don't need to be there, but you need to stop acting like a fugitive, okay? Do we understand each other?
Yes, sir.
All right. So I hope you can post and get out of there. The sooner the better. If you can't, then you're going to have to spend the night there and I'll think about what I'm going to do with it. All right?
All right, sir.
Good luck. Dorian Darzell Jones, 21M9188849, 26M. I'm sorry, and that's it. Now, your name.
Dorian Garza.
You were issued this citation in 2021. You didn't show up for your show cause for failure to pay in February of 22. February of 22. So here you come in now, 4 years later, and you're asking for time to pay.
Yes, sir.
I must be out of my mind.
Sure.
No, I must be. I must not just quite understand. Now, I didn't say everybody was wealthy. I don't understand the lack of respect. I don't understand it's somebody ignoring the court for 5 years and then walking in and saying, Judge, I haven't paid a nickel. I want time to pay. I just can't relate to this. But it happens every day, so shame on me. Shame on me. Where do you work at?
I work landscaping.
How many hours do you work?
Depends on the week. It's been real rainy lately, anywhere from 30 to 50 hours.
Why haven't you come in and talked to us since 2021 on this ticket?
Because in the process of me getting the ticket, I was moving. And
Don't tell me you forgot.
no, not that I forgot. I never got the paperwork.
Never got the paperwork. So you didn't think to call the court and say, hey, a police officer wrote me a ticket and he handed it to me on July 13th. I know it wouldn't take you guys 5 years to process it. I got a show cause in 21. How old are you?
I'm 26.
Did you graduate?
Yes, sir.
When are you going to grow up?
Process of doing so now.
How much money do you have today?
I don't have anything today, but I get paid tomorrow and I can make $150 payment tomorrow.
Well, why don't you wait to come in tomorrow?
Because I have work tomorrow and I don't want next work.
You married?
Yeah, no, engaged.
Do you have kids?
Yes, sir.
How many?
3.
How much can you afford to pay per week after you pay the $150 tomorrow?
$50 to $100 a week.
I'll make it 30. You pay $100 by May the 13th. Then you pay 30 per week. Jeez. Beginning May the 22nd. Okay.
Okay.
If you need more time, no problem. Call the court. We'll go on Zoom. Honor before the due date. Or you walk in here. Honor before the due date. I'll be happy to give you an extension. Okay.
Yes, sir. Thank
Good luck. Is Willie Hines here?
Judge, I have somebody in the breakout room that says Will's phone, not the breakout room, the waiting room that I've been trying to contact to get a name. So he could be here.
Hi.
Okay. Can you start your video, please, Mr. Hines? There you are. Good morning. Your
Good
name?
morning, Willie Hines.
Okay. So you're
Hey,
here.
listen, give me 1 second. I'm sorry. Yes, I'm here. I'm also at work. I'm sorry. I'm stepping out. Okay.
Amy, I thought we were handling civil infractions on our own. Am I wrong? I'll talk to you about that. Jeez. Do I have Trooper Martin here?
Yes, sir. I'm right here.
Okay. Good morning, Trooper. Your name?
Morning. Trooper C. Martin, sir.
All right. So he is charged with speeding
Yes, sir.
11 to 15 over and you warned him on a seatbelt and improper registration display.
Yes,
Any
sir.
offer here? He's got a clean record, it looks like.
I can do 1 to 5 over on the freeway for him.
All right. Do you want to do that, Mr. Hines? That would be 0 points, but it would go on your record. It's a limited access, 75 and a 70. Do you want to do that?
Yes, sir. I also wanted to explain what was going on that day. If I can have like a minute just to, just to explain things.
Well, I can't do anything with the charge, but I
understand.
can consider reducing the fines depending on what you're going to tell me. Do you want to
Okay.
plead the 75 and a 70 first?
Yes, sir.
To
Yes,
that
Your
charge,
Honor.
responsible or not responsible? Responsible or not responsible to 75 and a 70?
Responsible.
All right, I'll accept the plea, dismiss the 11 to 15 over. What would you like to tell me?
Okay, Your Honor, I came to Michigan because my sister had a stroke, and I was visiting her. And as I was visiting her, I had to cut it short because I got a phone call. I'm a single dad, 100% single, just me and my boys. And the mom was taking the boys, the visitation, and I got a call from her stating that she was in an accident. So I left there, and yes, I was driving. I was distraught. When the officer pulled me over, I was in tears and crying, and I was trying to explain to him that I was speeding, but I didn't recognize how fast I was going. And when he put me over, he said, "Well, if you can prove to me that your kids was in an accident, I'll give you a warning or whatever." I don't remember exactly what he said. I don't want to quote him. I'm sorry. But I called her up and I said, "Well, can you put the state trooper on the phone so he can speak to the officer so, he'd think that he'll know that I'm not lying?" And I guess he had another call or something. When he came back, I went to him on the phone and say, "Here, the state trooper's on the phone."
Listen,
He's like, "Well, I'm sorry."
I always charge 150 on these, okay? Because you got a clean record. I'll make it 125. Fair enough?
Yes, Your Honor. Thank you so much. It was
All
just a bad week. And I
I
did
understand. Did you get your plate? Did you get your got to wear your seatbelt though, and you got to have your
No, I
I don't
had
know
it
what
on,
was
Your
it.
Honor. I had it on, but I have a neck injury. So when I don't have it across my chest because sometimes like when I look over and I'm trying to back up, it hurt, it pulls and hurt my neck. But I had it around my waist. But I was
Okay.
showing him I had a
That
paper
doesn't
with a
comply with the
doctor.
law though, sir. You better get a letter from a physician if you don't intend to
I
put the
had one.
show.
I had one, but he was in too much in a rush to see it.
Okay. Well, he didn't write you though. He was nice
Yeah,
enough to not write you
and
and
I
not write you for
appreciate that.
improper display. Okay. Can you
Yes,
pay
sir.
this today?
No, sir. I mean, I'm
When can you
struggling
pay?
right
Just
now.
tell me when you can pay it.
Can I how much do I owe total?
125 is all.
Oh, I can pay that Friday.
Okay. I'll give you
Yes.
till Friday. That is the 15th. Okay.
Yes, sir. Thank you, Your Honor. I appreciate it. Officer, I do apologize.
Good luck.
Thank
Yes,
you,
sir.
sir.
Thank you.
All right.
Jesse James Scarina. Is that the only one you have, Mr. Gonick? 23F712753?
It is. There was some confusion about Miss Cowger, but apparently what happened was I was assigned to represent her. Then Miss Schlussel said she was retained. I think she had a conflict, and then they reassigned Mr. Dox. And
I
Miss
saw that. I saw that. And I thought they were going to reassign you. So
yeah, no worries. But in any event, it all worked out. But all I have is Mr. Scarino.
yeah, he's not here though.
He's not
Is this-
returning. He's not answering my calls either. I've called him like 3 times this morning.
Well, it was scheduled for 9:30. Your name?
Good morning, Your Honor. As on behalf of the people, BAA 100.
Anything else, Mr. Gonick?
No, sir.
I'm going to go ahead and issue a bench warrant and forfeit the bond.
Okay.
20,000, 10%. 20,000, 10%. So that's it. Have a great day, Mr. Gonick.
Okay.
Nice
Okay,
to
you
see
too,
you.
Judge.
Thank you,
Thank
Mrs.
you.
Morrow. Thank you. Boyd, Charles Vahan Boyd, 26W706997.
Good morning, Judge and staff. John Gottsman, 30 man, Charlotte, Lloyd.
Your name, sir?
Sure, I would.
Okay, I just want to be clear. These are just recommendations here, right?
That's correct, Judge.
So he's going to plead to attempted DV, which means he must have had another DV, right?
That's correct, Judge.
This is punishable, sir, by up to 250 fines, 45 days jail. Court costs are all those. And they're recommending parenting classes, anger management, 12 to 18 months probation, no contact with the victim, and anything else additional determined by the court. Do you understand all that? Yep. He didn't sign an advice of rights today.
Judge, I explained the advice of rights to him.
Is that right? Your lawyer went over these? Yes?
Yes.
I want you to come up here, John, and hand that to him, will you please?
John.
I want you to sign that advice of rights. Take your time. If you want, I can go off the record. If your lawyer's already explained to it and you fully understand it, you can go ahead and sign it. And then call Flat Rock on Mr. Little. That's all right, as long as he's.
Okay, thank you, Judge.
Did you sign, read, and understand the advice of rights?
Yes.
This one here, if you plead guilty, you're going to be giving up all those rights, and we are not going to have a hearing or a trial of any kind. Do you understand that?
Yes.
And is this how you wish to proceed?
Yes.
To the charge, attempt domestic violence, how do you plead?
Yeah.
On March 27 to 26, were you at 23030 Fairway Drive, apartment 202 in the city of Woodhaven, county of Wayne?
Yes.
And were you married to, at the time, Tahari Marie Boyd?
No, that's his daughter, Judge. Let me explain. This is,
Okay,
it was the use of parental discipline that.
okay.
A little bit of.
Tell me what happened.
So I actually had full custody of my daughter. She lives with me full time.
Go ahead.
Okay, so we were at home. She got upset because I wouldn't pay for her driver's training through her phone. She told me, Dad, fuck this shit.
What did you do?
And she had popped her mouth.
You hit her in the mouth?
Well,
He slapped her.
You slapped her in the mouth?
not in the mouth, but
Well, you said in the mouth. I'm not putting words into your mouth. You said he slapped her.
it was like a.
She got popped in the mouth. Were
Yes.
your words? Was that not your words?
Yes, sir.
She hit your daughter in the mouth. Yes?
Yes, sir.
How old is she?
17.
Shame on you. Are you on probation or parole? Anybody force you to plead guilty?
No,
You don't think that's reasonable parental discipline, do you?
no.
How big is your daughter?
Maybe it's height.
Yeah, height.
Oh, 5'8",
How tall are you?
6'1".
And you are how old?
I'm 43.
Why are you doing it?
I'm sorry about that, dude.
Why you slapped her in the mouth?
It wasn't.
Judge, he made a big mistake. However, there are a few things they were arguing for an extensive period.
I know, but
It just, again, he
are you
didn't
on?
use reasonable parental discipline.
What's that?
He did not use
Correct.
reasonable
Yeah.
parental discipline.
Are you on probation or parole, Mr. Boyd?
No, sir.
How many domestic violence convictions have you had?
Well, it's from maybe 16 years ago.
And whom did that involve?
It was her mom.
Are you still married to her
We
mom?
were never there.
Okay. Has anybody forced you to plead guilty or promised anything to induce you to plead guilty?
No,
I'll accept the plea to attempted DV. Dismiss the DV. Were you under the influence of any alcohol or drugs?
no.
Pre-sentence report is ordered. Pre-sentence report is ordered. I want to have let's give them a few weeks. I'll tell you what, I'm going to set this for June the 9th. Okay, Amy? June the 9th at 8:30. All right?
Yes.
Yes.
Come on. You seem like a nice guy. You have no business doing that.
Judge,
The physical damage you caused was like one half of 1% of what you caused mentally and emotionally. Come on. We don't hit our daughters in the mouth. Come on.
I will look. Okay.
basically, once you read the report, you realize that Mr. White is a better person.
I believe it. He seems like a nice guy,
He
but
works in Ford. He's the sole source of support and,
I get it.
discipline for this. Talk for
Good luck. Sterling Wright. Sterling Joseph Wright, 26B 703-678. Is Sterling Wright here?
Yeah, it's on Zoom, Your Honor.
Where is he?
Judge,
Monroe County.
here with Monroe County, and now I do not see them out there anymore.
Okay. Your Honor, Attorney Don Tucker Davis, P59229. I have spoken to Mr. Wright earlier. We have a meeting set up in person at 3:30 today. The paperwork was done and he is agreed. We do have a date set up for May 19th at 11 a.m. for a preliminary exam already. If I could waive his appearance.
I'll do that for you. What time was this scheduled? 9:30. You've been out there a while. Continue to exam May 19th at 11 a.m. And she's saying if you decide to waive, she has no objection. If you're going to do that, since she's got that in the file, I'd prefer that we tell him when if you're going to waive, you could either, let's try to do it before then, if you decide to waive, so they don't have to bring in their witnesses. But otherwise, I've got it at May the 19th at 11 a.m. Okay? People against Jesse James Scarina, 23F712753. So apparently he was out in the hallway, Mr. Gonick, and it wasn't his fault. So your appearance.
Ben Gonick for Mr. Scarina.
Your name, sir?
Jesse James Scarina.
All right. So initially I got a waiver from the prosecutor saying that no objection to waiver. Does your client still wish to waive his right to an exam?
Well, Your Honor, after I discussed it with the prosecutor, I did get an email from the Veterans Treatment Court, and it appears that Mr. Scarina may be eligible. So what I was going to respectfully request is an adjournment of the PCC a couple weeks to see if he's eligible.
Okay, so that would be where at? What Veterans Court?
I think it would be downtown. It was from Mr. Mara from the Specialty Court Coordinator, so it may be should have to go downtown, I would think. I would
assume, unless you received it from a district court that said that they would take him after they had consulted with Mr. Bresnahan. But I don't mind. You think you can take care of it in a week or not?
Yeah, why don't we take care of it in a week, and I'll reach out to Mr. Mara and find out what exactly I need to do, because this could really work to his benefit.
Okay, no problem. So the PCC will be May the 19th. And that is going to be are you good at 8:30 next week?
Yes, I am.
And then I'll set the exam for May the 26th at 10 a.m. Okay? So you're going to go consult with your lawyer further, not today. He's going to talk to the Veterans Treatment Court in Detroit. And I'll adjourn this out and we'll go from there. Now, the only thing is, I don't know how they do their Veterans Treatment Court, but it seems to me that would be predicated on him waiving his right to an exam or holding the exam. I just don't want them to put him through a bond phase while I have this felony sitting here, okay?
Correct.
So good enough. That's what we'll do. So sorry about that. And we're not going to issue the warrant or forfeit the bond. Go down the hall. They'll give you your paper notices and we'll see you here, okay?
Okay, thank you.
Best of luck. Mr. Harry, how are you?
Hello. Good afternoon, or good morning, I'm sorry.
Your name?
Robert Michael Harry.
I remember you. Remember?
Yes,
you
sir.
Remember me? You know why you
Yes,
remember
sir.
me? Because I was kind enough to let you show up the next day or a couple days later to serve the jail term, right?
Yes, sir.
And then you didn't come back, did you?
No.
Oh, geez. Wow. I've been kind of waiting for you. See, when I go out of my way to be nice to people and they look me in the brain, in the eye, and then you were actually the guy that told them, you know how good a memory I got for an old guy, Mr. Harry. You were the one that when you finally came back in, You told them you weren't sick and you were sick and they had to take you to the hospital. Do you remember that?
Yes, sir.
Wow. Am I shocked to see you in jail? I am absolutely unequivocally shocked. I was sure you'd be running the country or at least head of the Roman Catholic Church by now. You want to play games? You like playing games, Mr. Harry?
No.
So what's he here on? What could it be? What could it be, Mr. Westmoreland?
I believe he failed to appear at a show cause hearing.
My gosh, you got to be kidding. I would have never thought it was such a guy. I would have never thought it was such a guy. You don't have any respect for the system at all, huh, Mr. Harry? You think this is some kind of a joke?
No, I was just in jail for 17 months. So
Too bad. Too bad.
Okay.
This shocked me. I would have bet $1 million against a cup of coffee that you'd have been in for a lot longer than 17 months by now. So he's here to start to serve his jail term, right? Is that what he's here for?
And to take care of this matter, Your Honor, I believe he did send numerous letters while he was incarcerated, but Oakland County Jail couldn't get him on the screen.
Wow, I didn't say it was okay. There's nothing shocking about it, Harry. Mr. Harry, I know myself better than you know me or anybody else knows me. I know what I'm tolerant of and I know what I'm intolerant of. So is he in Oakland or Wayne?
He's in Wayne County Jail now.
How long are you? Do you have any other time to serve?
Yeah.
For what?
Probation violation.
Oh, did the judge there in Wayne County give you extra time to serve your probation violation?
I got 9 months in the Wayne County Jail.
Starting when?
I finished it up and I just did a year in Oakland.
Oh, so you've been in there 21 months?
17 months, yeah.
17
Correct.
months. Wow.
This is definitely a lesson learned.
Yeah. What does he want to do? Does he want to plead guilty to failure to serve his jail term, or what does he want to do?
That's correct, Your Honor, and failed to appear for his show cause and failed to pay costs and fines.
Oh, and Beth, tell them to calculate how many days credit he has coming on this one. If you plead guilty here, I want you to understand you could get 93 days. Do you understand that?
Yes, Your Honor.
You're presumed innocent. They have to prove you guilty by a preponderance of the evidence. You have the right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you're giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that?
Yes, Your Honor.
To the charge that you failed to serve your jail term, how do you wish to plead?
Guilty, Your Honor.
Did you fail to serve your jail term as ordered?
Yes, Your Honor.
Did you fail to report to jail at the time that you were supposed to report to jail?
Yes, Your Honor.
Anybody in this world forced you to plead guilty or promised you anything to induce you to plead guilty?
No, Your Honor.
Please accept it. I think he's got, I could be wrong. I think he's got, oh, he doesn't have anything, any credit. Do you have any credit coming other than the initial day?
I'm not sure, to be honest.
What, you're just making a mess of your life, huh?
It was horrible. I hit rock bottom.
Beth's coming in on Zoom?
She's unavailable. She's not somebody else.
Wow. Do you have any reason to believe you have more than 1 day credit coming for this?
No.
I don't think it's necessary for me to go through all the probation violations. Do you, Mr. Westmoreland?
It's up to you, Judge.
I don't think there is. He didn't appear. He was supposed to serve his jail term. Does he acknowledge he didn't do intensive outpatient treatment, victims impact, or AA, and then submit to chemical testing? Do you acknowledge all that, Mr. Harry?
I do, Your Honor. It was a rough time through my life. I made some not smart decisions.
Is this just alcohol or drugs too?
It was drugs too.
What kind of drugs?
Cocaine. I've been clean now. I'm in a program. It's a work at health app that I've been, even on this probation, I've been being, drug tested and, everything's good.
Well, you've been in custody. It's hard to use cocaine when you're in custody, isn't it?
I have probation for this case. I'm trying to wrap up all my warrants, and because life has just been spiraling downhill.
You're not trying to wrap up your warrants. You didn't bother to show up here. You're not trying to wrap up your warrants. Here's the good news, Mr. Harry. You want to know the good news or the bad news?
Both.
Which would you like to hear first?
The good news.
Well, the good news is, as agitated as you've made, and you did agitate, because I don't like people that play games with the system.
I understand.
I don't like it at all. I mean, if you can't be respectful of the greatest branch of government in the greatest country in the world, then you can't be respectful to anybody or anything. The bad news isn't from your standpoint, it's from mine. Because I got to feel good when I go home every night. And I go home and I think about what I do a lot more than people can possibly imagine. Was I fair? Was I too fair? Was I too harsh? Was I this? Because that is what decent judges do. That's what decent judges do. And I don't like people, like I said, that don't respect the system and ignore the system. It's just not something I was brought up to be. It's just not something, the way I was brought up, that I would ever think about doing. That being said, you did send me letters. And that being said, I'm going to let my pride and my desire to give you more days, and I'm not going to do it. I'm not going to do it. Because you see, even though that would be vindictive and I could feel good about making somebody recognize that they were so incredibly disrespectful, it's not appropriate. Not for me. I won't do that. So what I'm going to do is I'm simply going to give him credit for time served.
Thank you, Your Honor.
Because I'm being a lot more fair with you than you were with me. Do you agree with that?
I 100% agree with that.
Maybe, just maybe, next time, if there is a next time, and I hope there's not, that you will consider showing a little bit of respect. But just know that this is why this is the greatest system in the world. Defendant given credit for time served, case closed. Good luck. I really hope you turn your life around, sir.
Your
Good
Honor,
luck to you.
as far as costs and fines.
I'm just closing the case.
Okay, thank you, Judge.
Balance, fines, costs waived. So I'm giving him 92 days, Amy, credit for time served. Good
Thank you.
luck.
Thank you, Your Honor.
No, I don't. I figured it out on my own. Thank you.
Okay. I'm looking at 3 cases. 25 CR 367, which is operating a motor vehicle while intoxicated, third or more. There's all of these are bad. But this one was indicted over a year ago, and there's been no, we had initial docket. No. No. I don't see any resettings at all. This is a brand new resetting, but it was over a year ago. Then July of last year, a second DWI rolls around. Third. And then here, April 1st, this year, last month, a third DWI rolls around. Why has it taken so long for him to show up in court? I'm asking you, have you been traveling around or what?
Oh, no, sir.
Well, you picked up 3 separate DWIs on different occasions. Do you know that? Do you know that, or
Yes,
you're not aware of this?
Yes, sir.
Okay, you've been arrested 3 times, and you were indicted. One of these is September of 23. We're going on 3 years. Gosh, and nothing had been done. Where do you live?
105, Highway 105.
Yeah, there it is. You were at, I have these addresses as Windmere.
Yes, Windermere, Highway.
But that's where you live.
Yes, sir.
You didn't know you had a case pending 3 years for 3 years?
Nobody ever told me.
No, somebody's supposed to tell. Weren't you arrested?
Yeah, I got
3 different times.
And
You think they're gonna come to you? You didn't think that maybe you ought to take the offensive on this and be proactive to figure out where things are? Because what you've done is you did one. You, according to this indictment, you committed 1 third-degree felony, then you picked up another third-degree felony, and then you picked up a third one. You see anything wrong?
I see.
Oh, do.
Yes, sir.
And we're going to take care of things here because this is serious. And on the last one, that was just indicted, not only do you have a third-degree felony, but they have added 2 prior convictions, burglaries back in 2017. So this third-degree felony, if you're found guilty of this, it becomes punished as a second-degree felony. If this is correct, you're looking at up to 20 years. So you're looking at a total of 40 years in prison. Well, no. On the first one, a prior conviction is alleged, but not on the second one. So you're looking at in 367, up to 20 years in prison. On 501, up to 20 years, and then up to 10 years in 840, 50 years in prison. You want to look at me like I can't believe it's not butter. You know better than anybody else what kind of trouble you're in. This is really disturbing. Did you drive up here?
Yes, sir.
Who? Why not?
So
Why not? Did you walk up here? You walked up to the, sir?
from where?
How'd you get to work?
I had my drive.
Where's your car? Where's your vehicles? Why not? Why don't you have a vehicle? Speak up, so.
I don't have a vehicle.
When did you, well, you had vehicles here.
Yeah,
Where'd they
I
all
haven't had
go?
a vehicle in probably about 2 years. Or a year and a half, so.
No. The day before January 1st of 2025, which is a year and a half ago, you were arrested.
Right.
So a year and a half ago, you had a vehicle.
That's what I said. Said I hadn't had a year.
No, you said
A
2 years.
vehicle in about a year and a half.
It's for misdemeanor.
I'm sorry. Go ahead, Langston. What are you going to?
No, I was just asking to put him
on
on
all of it. This is a mess.
Right. I was going to actually put him on the announcement from the initial, and that way I can go through his discovery with him, meet with him, and then we can come up with a plan on trying to resolve all of this. But I did get all of his discovery, and I have all that downloaded from the DA's office.
I have one on
What are his bonds on each of these, please?
On 0367, it's $35,000. On 0840, it's $35,000. And on 0501, it is $15,000.
The more you commit offenses, the less the bonds are. Go figure. I mean, this is a Twilight Zone episode. What was the last one again?
15,000.
Woefully low. But you got more problems. You got a warrant out for your arrest right now for resisting arrest. You're going to be taken into custody. That's the first thing. The bond in 26501, which is the third pending felony that you've committed here after the September 21st, 2024 incident and after the September 23rd, 2023 DWI third, then on or about December 31st, 2024, you committed a third one here after those other two, and then that bond this court finds is the first two bonds were 35,000 and 35,000, and then thereafter you commit a third offense of a third degree felony, which is enhanced because of two prior burglary convictions of habitations in 2017. So this is now a second degree felony. And then for some reason, the magistrate's bond reduced, so which defies any logic. So we're going to fix that. That $15,000 bond is revoked, and that's a $70,000. It doubles $70,000 bond. And then you're going to be arrested here for this capias and taken into custody for this misdemeanor that's pending. You cannot operate a motor vehicle unless right now, until this court allows you to, because this is a disturbing, I've never seen this. 3 successive third degree felonies over and over, which means you don't get it. And the rules don't apply to you. But again, you're talking about 50 years imprisonment on all of these. And that's going to be treated seriously. You can't operate a motor vehicle until further orders. Also, are you an alcoholic? Do you have an alcohol problem?
So I believe I do.
You believe you do. All right. Okay.
We'll have that.
Well, we're gonna work on that too. What the state suggests on just for testing on him so that, because I don't want.
Well, since
To drink now.
one is for alcohol, one is for marijuana, we probably have to have the scram and a patch, drug patch.
Make sure we cover all bases.
You're just free falling right now, sir, as you know. And we're gonna have to fix this since you can't fix it yourself. So you will be ordered to have a drug patch and you will be ordered to have a scram device which tests you for alcohol, but you were unable to operate a motor vehicle. You are right now free falling and you are not safe operating a 4,000-pound missile around town. You just get arrested over and over again. We're lucky someone hadn't been harmed or at worst killed by your reckless behavior. Do you understand?
Yes, sir. I do.
You'll be taken into custody here immediately.
You're an approach.
And no, hold on.
Sorry, I thought you were about to.
Yeah, I am, but you're gonna be next. Langston, what do you have to say? Anything else?
I didn't know about the resistant.
Well,
I just want to put on the announcement.
We're gonna make a copy for you.
Okay, that'll work.
And you want to put it on the announcement docket, right?
Yes.
Okay, it'll be placed on announcement. Okay, what else on this? You'll get a resetting too. And if you're, we'll get you up here if you're in jail, but you've got my attention, and the 250,000 people of this county are going to be safe with you not being around town, driving a vehicle improperly, recklessly, and without regard to other people, much less yourself. That is all. You're in custody. Yes, sir.
Judge, you added on one for Langston from yesterday. He was on the trial docket. You asked me to bring it
What,
back.
Langston? What is it? Swafford, Quinn Swafford.
I know that. I think I know the Louisiana.
It's an added. Quinn Swafford.
He's here.
What are we doing?
Well, he was released yesterday. He's my guy that was on trial docket that had a real bad medical condition. He suffers from.
Are there any other kinds?
Well, he's
of medical conditions, but bad ones.
Right. Well,
I've never had a good medical condition.
Right. Well, the lady, his caretaker was explaining that he's bedridden, and they have to have a particular device now just to keep him upright in that wheelchair. And I know he couldn't sit through a trial in his current condition.
I'm sorry. Okay. He is a habitual felon, right? He is indicted as a habitual felon. He's looking at a minimum of 25 years in prison. We always look at this real closely. And also this one's going on 2 years old. What are we doing? Are we having a trial on it or not?
I think that we were yesterday.
Well, let's get to trial. When can we try this thing?
Well, whenever you want to sit down.
Put it as soon as possible.
Cool. That's no problem.
What else do you want to do?
That's it. I think we're good.
I think he wanted to revisit his bond. You had read some kind of email from somebody at the care facility he was at.
Okay. Can you make a copy of this? Here. Yeah. He's at a facility, right?
Yes, he's at the one in Port Arthur.
Yeah,
transport.
But he's checking himself out and then testing positive for cocaine when he comes back to the facility. And that they find that to be not just amusing, but illegal and inappropriate. I'm going to make you a copy of what we sent, what we've got. But he's signing himself out He's on his own. He's not following the rules, and he's testing positive for drugs. I see things wrong there. He's not trusted. Yep.
I don't want to misspeak and say something inaccurate.
Yeah, I'm going to give you all the copies of
No.
what has been sent to me, so you have it all. Okay. Here's another. Here's
Right.
another one. If you hear it.
I don't want to misspeak, and that's why I'm going to
Here, read that.
Yes, sir. To look at the computer.
Everybody gets a copy of
But I
it.
do believe.
Also, there's another
Mhm.
mail that was sent to us about another event. Yeah. He's been continually signing himself out of the facility over the weekend. The resident was at the hospital due to cocaine usage. He tested. I didn't know that. Nobody told me about that. Why don't I know about that? He tested positive for cocaine and marijuana at the hospital. I'm not sure this is a violation or not, but I wanted to inform you. Yeah, it's a violation.
No. What I was saying is that, and Mr. Laird can confirm it on his computer
Yeah.
whether I'm accurate or not. But I thought that they had released him from the jail due to his medical condition. And it got, because he was bad off, and I was saying that to put him in, I'm not sure that the jail, and like I said, he can check it. I don't know.
No, he seems like he's, according to this, he's doing pretty well on his cocaine usage and checking himself in and out without authority. But that all is almost laughable. No, he's on his own conditions of bond, which isn't the way here's another one, Mike. Isn't the way it's supposed to work. He doesn't make the rules. He's supposed to follow the rules. He's not doing it. His bond is going to be revoked. What's his bond right now, please?
$20,000.
Yeah, it's doubled to $40,000. Plus, he must have a GPS device so we know where he is at all.
Posted a $20,000 surety bond.
So he posted it.
Yeah, this wasn't anything about it.
Plus, he has, and every time we catch him out, we'll keep doubling his bond.
$20,000 bond.
And we're going to test him just today too, as we take him in. Ryan, you got something? Go ahead, come on. Thanks, Langston. Sorry about that.
No problem.
Mr. Swafford? Swafford?
Mr. Swafford, he's with us.
You think that?
All right, bring him out.
It's gotta be, gotta do.
Yes, sir. All right. There's the.
Oh, you have Swafford?
Langston does.
Langston?
But you already raised the bond, that was just bond for 30,000 plus the GPS device. And then you.
I just need to bring him out and put something on the record here quickly on Swafford. He flunked.
Mr.
What was the betting line in Las Vegas on that?
Yeah.
Las Vegas wouldn't touch it. Mr. Parker,
Mr. Swafford.
Not yours, no, I'm sure it's not. Yours hadn't tested yet.
No,
I think you
he
did
had
right
pretty
now.
much admitted it.
Mr.
He admitted it.
Yeah.
Mr. Swafford, as you know, your bond has been revoked here, and also we've just finished the drug test. You tested positive for tetrahydrocannabinol, marijuana, and again, you're coming to court with illegal drugs in your system, and that is a condition of bond one. Do not commit an offense, and illegal usage of marijuana is enough to satisfy that bond condition as a violation in your case by preponderance of the evidence or greater. And for that other reason, your bond is revoked. Also, I think I ordered a drug patch.
Ordered a GPS device.
I'm ordering now a drug patch as well as a condition of your bond as well, sir. And we will get that information over to your attorney. And so he will know, okay? Thank you. That is all.
Next, we have the works watermark matter. We had a fairly lengthy hearing yesterday. Ms. Hansel, you may know your client is incarcerated.
I was not aware of that. No, I did not know that. I've been trying to get a hold of her, but I didn't know where she was at.
Go ahead, Mr. Brown, were you going to speak?
I'm sorry, I was just going to advise Ms. Hansel that she is incarcerated. She is going to be arraigned this afternoon.
Right. Ms. Hansel, do you want to speak to her, to get a breakout room with her as soon as she appears?
Yes, that would probably be appropriate, Your Honor.
Okay, we had a hearing yesterday, as you know, and well, it's a fast moving case in some ways, and I'm not sure where things are, but I think she's here right now. Okay. Just for the record, Mr. Sommerfeld is here, Mr. Brown is here, Ms. Hansel is here. Ms. Burns, can you hear me? I think they're trying to get you unmuted there.
Yana, can you hear us?
Yep, we can hear you now.
I can answer.
Ma'am, are you Soraya Burns?
Yes, I am.
All right, your attorney is Donna Hensel. She is here. She needs to talk to you. We're going to put you in a breakout room so she can have a private conversation with you.
When they do that.
Ms. Hansel, apparently I'm going to be seeing you this afternoon on an arraignment as well, ma'am, at 1:15. But this right now is a child protective proceeding. But Mr. Brown, have you talked to her?
I have not, Your Honor. I believe the arraignments may be before this court here coming up.
Yes.
Okay, so after the morning docket, I will be calling over to the jail.
This has been kind of a fractured case in some ways. I do recall the very first hearing that I had. I did not go over the petition with Ms. Burns. I probably went over her rights, but I'm going to do that again. Ms. Hansel, you have spoken to her, and I will ask her this, but do you believe she wants me to read the petition to her, or do you think she understands it?
I believe she may want you to read it. Although I've discussed with her the allegations in it, but I didn't have it to hand to her or at that point. So I guess that I'd leave that up to her, Your Honor.
Okay, Ms. Burns, I'm going to go through your rights, one of which is to have the entire petition read to you. If you want me to do that, I will. I'll get back to that in just a minute. This is a child protective proceedings. I know you're facing charges, and we'll be addressing those at a hearing this afternoon, but that's not what this hearing is about. This is a child protective proceedings. Here are your rights in this, which are somewhat different than your rights in a criminal case. You do have the right to an attorney. Ms. Hansel is your attorney in this matter. If you hired your own, that attorney would replace Ms. Hansel. In addition to the right to an attorney, you do have the right to a jury trial on this child protective proceeding. At that trial, the petitioner, who is Department of Health and Human Services, would have to show that the allegations in the petition are true and are sufficient to allow the court to take jurisdiction. If they could not do that, it would be dismissed. At that trial, you'd have the right to have you or your attorney ask questions of witnesses against you, and you'd have the right to have the court order your own witnesses to be present. Do you understand your rights?
Yes.
All right. As to the petition, do you want me to read it to you?
Yes, please.
All right. Mr. Sommerfeld, I just want to make sure I'm reading the right petition. This is the first amended petition dated May 11th. Is that correct?
Yes. And Ms. Sullivan did provide a copy to Ms. Burns when the removal order was effectuated by her and some police officers.
I was not given that till this morning.
Pardon me. The voice will be back in just a second. All right. Ma'am, this is about a hearing involving Aaron Bordermark, excuse me, and Quentin Wirtz, alleges that they are residents of Otsego County. They are minors, and you are their mother. All right. Yeah. Wow. Anyway, the allegations involving you allege that on October 29th, Child Protective Services received the following complaint. Law enforcement was dispatched to your home. And remember, I'm not saying these things are true. I'm just saying these are what are in the petition.
I understand.
Indicating you were highly intoxicated, wanting to leave home with Quentin, which resulted in a domestic dispute between you and Daniel. This is a concern, law enforcement, because it is ongoing. Law enforcement has been to the home numerous times due to the parents drinking and starting arguments that lead to the children becoming involved. It is unknown whether the children have been hurt or injured due to the disputes. On or about December 2nd, 2025, Child Protective Services received the following complaint. Law enforcement was dispatched to the home due to a domestic dispute between Soraya, and Daniel. Additionally, the couple reported the children to have been in the back bedroom and to not have witnessed the dispute. Daniel reported being pushed and punched by Soraya, and Soraya reported Daniel to have been trying to take her phone and to have her thrown across the bed. Soraya did have marks, and Daniel had scratches on him as well. The couple had been drinking. Soraya also broke glasses in the sink at some point out of frustration. Soraya had to exit the home through a bedroom window to escape the situation due to Daniel blocking Soraya from exiting the home. Daniel was arrested and later claimed the children witnessed the dispute. A Child Protective Services investigation was conducted and an ongoing CPS case was opened as a Category 2 intensive risk. Soraya failed to voluntarily participate in services. Subparagraph D, Worker Sullivan reviewed the updated case service plan as authorized by Child Protective Services worker Lawrence. Lawrence attempted to make contact with Soraya as follows on October 29, 2025, made contact face-to-face. December 3rd, 2025, made successful face-to-face contact. January 8, 2026, unsuccessful face-to-face. January 9th, 2026, unsuccessful attempt to make face-to-face contact, or two unsuccessful attempts to make face-to-face contact at the home. Another unsuccessful attempt to make phone contact on that day with Soraya. On January 12th, successful face-to-face contact made with Soraya. Soraya agreed to contact Child Protective Services the following day to schedule a family team meeting and did not make the contact. January 20th, 2026, unsuccessful attempt to make face-to-face at the home. At the same date, unsuccessful attempt to make telephone contact. February 6th, unsuccessful attempt to make face-to-face contact. February 9th, successful phone contact was made with Soraya. However, the call was dropped twice. Soraya advised that text would be best. On February 9th, Matthew Lawrence advised Soraya via text message that if she did not participate in services and participate in a team meeting, the department would need to seek court intervention. Subparagraph E, several attempts were made to engage Soraya in services. However, she has not participated in services and has had minimal contact with Child Protective Services since the case was open. F, Child Protective Services made several attempts to get Soraya to participate in a family team meeting in an effort to create a case service plan Soraya has yet to participate in a family team meeting. G, on or about March 13th, 2026, Child Protective Services Sullivan took over case management. H, on or about March 23rd, 2026, Sullivan and Delaney, Child Protective Services Delaney completed an unannounced home visit to the residence. During that home visit, the following occurred. Worker made attempts to engage Soraya in services. CPS Delaney and Sullivan were told to leave the property. CPS Sullivan was advised by Soraya that she has fully cooperated with the CPS case and that the ongoing case has been open more than 90 days and the worker is required by law to close the CPS case. Soraya advised that she was Native American and asked for assistance with tribal enrollment. Soraya advised that she was not willing to participate in any services as she has been cooperative with CPS Lawrence throughout the ongoing CPS case. CPS Sullivan smelled alcohol on Soraya while they were talking. Worker asked Soraya about drinking. Soraya stated she is an adult and the worker cannot tell her she cannot consume alcohol. Soraya advised she solved all of her issues and has not allowed Daniel back into the home. Paragraph I. On or about March 31st, 2026, worker filed a petition requesting in-home jurisdiction of the children as Soraya refused to allow the worker to view the children and verify their well-being. J. On or about April 13th, 2026, worker made contact with Aaron Vordemark. Aaron reported that Soraya no longer has electricity in the home. K. On or about April 13th, 2026, worker attempted to make contact with Soraya via text message to schedule a home visit with Soraya and the children. Soraya did not respond. L. On or about April 15th, 2026, worker attempted an unannounced home visit. Soraya's neighbor across the street began yelling at the worker that worker was not allowed on the property. The neighbor called the worker several derogatory names and filmed the worker. Worker sent a text message to Soraya letting her know the worker had been at the home and left the business card on the door of the home. Soraya did not respond. M. On or about May 2nd, 2026, worker spoke with Michigan State Police Trooper Hunter Schramm. Trooper Schramm reported that animal control had been at Soraya's home earlier that day, and the neighbor across the street had wielded a weapon at the animal control officer. Michigan State Police was called to Soraya's home to assist. Soraya's neighbor was arrested and later released, and no criminal charges were sought. It was later determined that this neighbor has been providing childcare for Soraya. On or about May 11th, 2026, worker was made aware that on or about May 1st, 2026, Soraya had consumed alcohol and was physically assaulted by two women in the neighborhood. Soraya had to seek medical attention for her injuries. On or about May 11th, 2026, worker was made aware that on May 5th, 2026, Michigan State Police were contacted to conduct a welfare check on Soraya as she had contacted her brother Nathan Burns, stating she needed help for herself and her child, stating she is being assaulted by a male in the home. Michigan State Police Trooper Cafferson responded. Soraya reported she had been assaulted by two female neighbors on May 1. Soraya reported the assault had previously been reported to the police. Soraya was observed with a black eye. Soraya's speech was slow and lethargic. Soraya refused medical treatment. Soraya denied she had been consuming alcohol to Trooper Cafferson. P. On or about May 11th, 2026, Soraya was advised that animal control and Otsego County Sheriff's Department the worker was advised that animal control and Otsego County Sheriff's Department were called to the home as a neighbor had observed another neighbor burying a dog. Animal control and Otsego County Sheriff's Department were able to obtain a warrant for the home. The home was observed to be in deplorable conditions and not deemed safe for pets to live in, and was certainly not safe for a child to be living in. Several sanitary and safety concerns were noted by animal control and Otsego County Sheriff's Department, including dog feces and urine throughout the home and several dirty dishes in the sink. There was no electricity in the home. However, the home did have running water. It was later reported that Soraya's well runs off her neighbor's home, providing her with running water. On or about May 11th, animal control removed two live dogs from the home and a bearded dragon that was initially thought to be deceased, but later discovered still to be alive but gone dormant due to no source of heat. Animal control also removed a deceased dog that had been buried along with 4 stillborn puppies. Initial veterinarian reports indicate the dog passed while birthing the puppies. The dog did not have any food in her stomach and was emaciated. There are pending criminal charges against Soraya for animal cruelty. Throughout the Child Protective Services investigation and ongoing CPS case, Soraya has refused to allow workers to view the inside of the home to assess the housing conditions. Soraya has also refused to allow animal control and law enforcement into the home. S. Soraya has followed relevant CPS, has the following relevant CPS history. June 13, 2018, Soraya was intoxicated and left the home with children in the vehicle. Soraya was arrested and the children were released to the father, Kyle Vertimer. December 3rd, 2023, Soraya assaulted both Aaron and Kyle, leaving marks while under the influence of alcohol. August 3rd, 2025, Quentin was wandering around the neighborhood and appeared lost. The home conditions were observed to be unsanitary. Reasonable efforts to prevent removal include prior CPS investigations, previous ongoing CPS cases, goodwill vouchers, several attempts to engage Soraya in services and safety planning. Relief, we request the department requests the court remove the children from Soraya's care, take jurisdiction over the children, place them in the care, custody, and supervision of the department. The department would further request that Soraya provide the department with any information concerning CPS whereabouts. That is what the petition contains, ma'am. I'm not asking for your response at this time. We are here specifically on a preliminary hearing. Ms. Hansel, do you have a position as to whether or not you wish to proceed with that?
Your Honor, we would add, in speaking to my client, we would ask for an adjournment today and so that the criminal matter can be determined once this arraignment is taken care of and she's figured out if she will remain in jail or not, and what conditions she'll come to. We feel like she'll be in a much better position than to discuss these matters with the prosecutor to determine if we would, if some type of plea would be appropriate. But at this point in time, with her still in jail and she doesn't know what the future holds or when she will be released, we would ask for an adjournment.
All right, that seems like a reasonable request at this time. Either Mr. Sommerfeld or Ms. Sullivan, I don't need testimony, and this can be very brief, but could somebody provide a summary as to what has occurred since the hearing adjourned yesterday afternoon?
Yes, Judge. After receiving the court order, Miss Sullivan went to Miss Burns' house. As alleged in the petition, the neighbor across the street was making some noise at the state police. Mom was not there. The police went over to the house across the street where the man was yelling, and it was determined that Soraya was in there. The door had to be forcibly opened, and the occupants were arrested, and they found the child inside. The living conditions were terrible in that house. There were lots of empty alcohol containers. Mom was arrested for resisting and obstructing police officers. That is probably what she's going to be arraigned on this afternoon.
And the child in question was Quentin?
Yes, and Miss Sullivan said it took a little bit of time, but Quentin, he went with her and Miss Servney, and everything worked out after that.
All right, and Ms. Sullivan, I'm assuming Quentin is in a licensed foster care at this time?
Yes, he is. He went to a licensed foster home last night. I did talk to the foster parent this morning, and she said he did very, very well once he was in the home and kind of got acclimated a little bit.
All right, Mr. Brown, do you have any questions about Quentin?
No, I don't, Your Honor.
All right, and I'm assuming from what I was told yesterday, Aaron is with his father.
Correct. He leaves for sixth grade camp tomorrow.
Okay, all right. All right, is there anything else that we can do at this point? I am going to grant the adjournment, obviously.
I have one question, Your Honor.
Sure.
Is our relative placements, is that something that's being investigated, or have you tried to find a relative yet or not?
Yes, did speak to Soraya and Nathan yesterday.
Ms. Sullivan, you're breaking up, at least as to me. Maybe if you got a little closer.
Oh, sorry. I did have contact with Soraya's brother yesterday. He was contacting a couple of relatives. I also talked to Aaron's father, Kyle, and he was going to contact Soraya's father. The way we left that conversation was with her. If her father's interested in placement, then he will contact me today.
Okay, all right. Just concerned, she wanted to make sure that those steps are being taken.
My stepmom as well. I have a lot of family in Sheboygan. My stepmom would be willing. I'm almost positive to help me and Quentin.
All right.
I just need to access the contacts in my phone. My phone is dead right now. I don't even have my glasses or anything. So I'm limited on what I can do and how I can reach out to people because I don't have a charged phone. I don't even have my glasses or the medicine for my back from the assault. I have nothing.
All right. Well, ma'am, I will see you this afternoon, I think at 1:15 for an arraignment.
Okay.
On the criminal charge or charges. And we'll take that from there. This matter will be scheduled for a continued preliminary hearing. We'll see what your situation is at that time.
Judge,
Okay.
can we all, there's an allegation and petition that where mom makes a claim about Native American heritage. I don't know if she has identified any potential tribes for the department to look into that, but that's an issue we need to address here since it was raised.
Ma'am, do you have any information?
Yeah, I didn't ask for it, but Matthew Lawrence had brought, he's like, well, if you guys, even if it helps the kids, he's like, if you guys do have a certain percentage of blood, it'll help the children later in life. And I said, okay, I said, if you're willing to do it. And I gave him my grandfather's identification card for our tribe. And I told him it was the Lake Superior tribe of Chippewa. He was supposed to be looking into that, and he was supposed to be looking into closing out the case, and then all of a sudden we shifted to new people and new case and
all right, but it's the Lake Superior tribe of Chippewa.
Yeah. And Varga.
All right.
So I can speak to that a little bit here. I did review the contact that Matthew Lawrence had with the tribe. He did send the paperwork to the tribe, and we did receive a letter saying that none of the family members were eligible for membership or for enrollment. Okay. So we did get that response back.
All right.
We just received that. We received that like late April. I think it was April 27th. We received that response. So it was just recent.
All right. Thank you. All right. So we'll see at least some of you this afternoon, and the rest will be at a subsequent hearing that will be scheduled. At this point, I guess, as we're not sure what's going to happen, whether Ms. Burns will be released or not, Mr. Summerfield, do you have a request concerning parenting time with the children? I mean,
I would ask that it be supervised by the department or designee. I mean, this is for reunification, so I don't know if her criminal conditions, I know because we haven't done the arraignment this afternoon, I don't know if that will prohibit any contact. However, our court order should allow supervised by the department or its designee.
And would that be as to both children?
Yes.
Mr. Brown, do you agree with that?
Yes, Your Honor.
And Ms. Hansel, do you agree with that as well?
I would ask my client's input on that. I would definitely want, if those are the terms and that's the only way she can have parenting time, we would accept that. I do think she had a question though, Your Honor. Perhaps you could direct her.
Go ahead, ma'am.
I didn't have any question, but yes, please, any way that I can see my children. Quentin's never been away from me. I've never been away from my kids. And to even have supervised visitation of some sort, that would be beneficial to the family.
I will allow supervised visitation supervised by DHHS or its designee for both children. I'm not sure that's in this case. I will handle the initial arraignment and Judge Hessling would handle the case after that. But obviously, if for whatever reason, in that case, there's a prohibition against contact, then there's a prohibition against contact. I'm not addressing that at all right now. I will address that later this afternoon.
Okay.
But they are two separate cases, potentially two separate orders. And the one with the more strict provisions would control. Okay, I think that's what we can do today. Sir, are you Todd Scott? Can you hear me?
Yes, Your Honor. Yes, Your Honor. Can you hear me?
Yes, I can. Okay.
Thank you.
And sir, you are Todd Scott, is that correct?
Yes, Your Honor, I am.
All right. And Mr. Scott, just so you know, there's a prosecutor here and standby defense counsel. The charge against you alleges that on or about May 11th of this year, you resisted or opposed Trooper Jacob Kennedy of the Michigan State Police Department in the performance of his duties. If convicted of that, you face up to 2 years imprisonment. The same thing as to Trooper James Leonard with the same maximum possible penalty of 2 years imprisonment. And count 3 alleges that you interfered with the custody of 2 minor children. Of 1 minor child, QW, a child adjudged to be a dependent pursuant to the juvenile code. And that exposes you up to 1 year in jail. Do you understand the 3 charges and the maximum possible penalty in each?
Yes, Your Honor.
I'm going to go through your rights. You have the right to an attorney. If you could not afford one, one would be appointed for you. You have the right to a jury trial on these matters. At that trial, the prosecutor would be required to prove your guilt beyond a reasonable doubt. If the prosecutor could not do that, the matter would be dismissed. At that trial, you'd have the right to remain silent. If you chose to remain silent, your silence could not be used against you. On the other hand, if you wanted to testify, you could. You'd have the right to have the court subpoena or order witnesses on your own behalf to be present, and you'd have the right to have you or an attorney ask questions of witnesses against you. Do you understand your rights?
Yes, Your Honor, I do.
All right. As to an attorney, do you plan to hire your own or seek a court-appointed attorney?
I'm not definite at this point in time, sir. I am a U.S. vet, and vets do offer a lawyer thing out of Saginaw, but I'll have to contact them first and find out if they'll take this case. Otherwise, I'm low income, and I would need a court-appointed attorney.
Here's what you might want to do. You might want to say, I will apply for a court-appointed attorney, and then you can check with the folks in Saginaw, and if they will take the case, that person can step in for the court-appointed one. You want to do it that way?
Yes, Your Honor, I will. I will apply for the court-appointed attorney and go from there.
All right, Mr. Trush, do you know whether or not he's eligible?
He will qualify based on the information that he provided me.
All right. So, sir, an attorney will be appointed for you. You reside at 6150 Kellogg Drive in Gaylord?
Yes, Your Honor.
All right. I will tell both counsel I am somewhat familiar with the facts of this, given the extensive hearings I've had on a related NA case. But Mr. Fortier, as to bond?
Your Honor, it appears that Mr. Scott has a very limited criminal history. He's only got 1 prior conviction, and it was for allowing a suspended person to operate in 2024. So at this point, I would be requesting a 10% cash assure or a 10% amount. I would leave it up to the court as to what that would be. I think maybe, somewhere in the neighborhood of $1,000 to $2,000, 10% would be sufficient. I would ask that the court not consider a PR bond just based on the circumstances of the charges. I think, some sort of bond amount would be necessary to ensure the protection of the community at large if he's willing to, essentially fight with police officers and CPS workers. That, is a little risky. In addition to that, I would ask that he report via community corrections and not have any contact with Soraya Burns.
All right, thank you. Mr. Shush?
Thank you, Your Honor. I would largely agree with what the prosecutor indicated. Mr. Scott is a retired veteran, as the court's probably already aware from what he said. He reported to me that he has no prior felonies. He did report one traffic misdemeanor, which is consistent with what the prosecutor said. Reported in that prior case that he had always appeared for court when required to do so. I would suggest to the court, again, I think a fairly low cash bond is appropriate. I think 10% would be an appropriate amount. And based on what Mr. Scott told me, that is a bond that he would likely be able to meet.
All right, I will tell you, Mr. Scott, I'm inclined to do that. A set of $1,000, 10% bond, which requires you to post $100. Are you able to do that?
Not today. I don't get my check until tomorrow.
All right.
But
will you have access? Pardon me?
I would have access tomorrow morning with that $100.
Okay. All right. And there'll also be an indication that you're not to have any contact with Ms. Burns. You know who she is, right?
She's my girlfriend, yes.
Yeah. And I realize this is not a domestic violence case, but she kind of lives right across the street from you.
Yes, sir.
And I realize there's some child protective service involvement, and I've heard some statements of your involvement there. You have to stay out of that. You understand?
I will, Your Honor.
They are not your children. If, whatever happens between CPS and her is between CPS and her. If you get involved in that, having contact with her or with CPS, yelling across the road, anything like that, you're going to be back in jail. Do you understand that?
Yes, Your Honor, I do.
Stay out of it, basically.
Okay.
Even if she calls you, all right, you don't have any contact with her. If she calls you, hang up. If she tries to talk to you, call the police, talk to your attorney, but just stay away from it. You're the one who's going to end up back in jail. Okay?
Yes, Your Honor, I understand.
All right. So with that, I will set a $1,000, 10% bond. You're also to report to community corrections. You can do that by phone. That number will be on the paperwork that you get when you're released. Do you have any questions for me?
Will I be able to be released today and pay the bond tomorrow?
You'll have to pay the bond. You'll be released when you post the bond tomorrow.
Okay, so I can go check and see if they put the money on my card today.
Well, do you have a card? Is that what they deposited?
I have a direct bank account. My Social Security check goes into the second Wednesday of every month, which is tomorrow. Some days it's in early and sometimes it's not until that day.
All right. Do you have access to that card or that account by phone?
Yes, I do here. Yes, it's here.
Okay. So you'll be able to post that tomorrow. But you'll stay there until you post it.
Okay.
And when you post it, there's two places you have to call. Number one will be your attorney, and we'll give you that person's name and phone number. And number two will be the community corrections, and that phone number will also be here. All right?
Okay.
Okay, remember, no contact with Ms. Burns.
Yes, Your Honor.
Okay, do you have any questions?
No, Your Honor.
Counsel, anything further?
No, Judge, thank you.
No, Your Honor.
Okay, we're all set then. All right, officer, we just need, Ms. Burns. All right, she'll be here in a minute. A gentleman on the case that I had this morning with her, the child protective case, I did issue an order that she can have supervised visitation with her minor child. Just so you know that, I told her also what happened in this case is separate from it. If there's a prohibition of that, that's there as well. But the supervisor would be DHHS or its designee. All right, Ms. Burns, can you hear me?
Yes.
All right, this is an arraignment. Standby defense counsel is here, as is the prosecutor. The charges against you are as follows. It's alleged that on May 11th of this year, count 1, that you committed the crime of obstruction of justice by refusing to turn over your daughter to Michigan Department of Health and Human Services or Michigan State Police pursuant to a valid court order. If convicted, you face up to 5 years imprisonment. Count 2 alleges that you assaulted, resisted, obstructed, opposed, or endangered Trooper James Leonard of the Michigan State Police Post in the performance of his duties and caused a bodily injury requiring medical attention, exposing you to up to 4 years imprisonment. Count 3 alleges that you resisted, assaulted, opposed, or endangered Trooper Jacob Kennedy of the Michigan State Police Post, exposing you up in the performance of his duties, exposing up to 2 years imprisonment. And count 4 alleges that you interfered with the custody of QW, a minor child adjudged to be neglected pursuant to the juvenile code, exposing you to up to 1 year in jail. Do you understand the 4 charges and the maximum possible penalty to each?
Yes.
I'm going to go through your rights. They're a little bit different than the rights I advised you of this morning, as this is a criminal case. You have the right to an attorney. If you could not afford one would be appointed for you. You have the right to a jury trial on these matters. At that trial, the prosecutor would be required to prove your guilt beyond a reasonable doubt. If the prosecutor could not do that, the matter would be dismissed. At that trial, you'd have the right to remain silent, and if you chose to remain silent, your silence could not be used against you. On the other hand, if you wanted to testify, you could. You'd have the right to have the court subpoena or order witnesses on your own behalf to be present, and you'd have the right to have you or your attorney ask questions of witnesses against you. Do you understand your rights?
Yes, sir.
All right. As to an attorney, do you plan to hire your own or seek a court-appointed attorney?
Seek a court-appointed attorney, please.
All right. Mr. Trush, is she eligible?
Yes, Your Honor. I discussed this with her. I believe she would qualify.
All right. One will be appointed to represent you in this matter, ma'am. As to bond, then, Mr. Fortier?
So, Judge, somewhat similar posture as the case prior. She does have a limited criminal history. There's a 2018 conviction for OWI, and that's it. However, this one, I think, is a little different in the sense that naturally one of the things, the things that the court has to look at is one, when issuing an appropriate bond, is the community's safety and her appearance at court for all future proceedings. And in this one, I do need to inform the court. I was advised by Deputy Caleb Dean with the Sheriff's Department that one of the witnesses in a separate case that was just authorized today against her had advised that the child that was recently removed was very, very upset in reporting that essentially Ms. Burns had stated once she bonds out or gets out of jail on this case, she's fleeing the state of Michigan. So I would ask the court to take that into consideration. I know it's obviously hearsay, but hearsay is admissible in these sorts of proceedings, and I think the court should take that under advisement when deciding a bond amount. For this one, Ms. Brooker had recommended $10,000, 10%. I don't necessarily disagree with that, and I'm not going to ask the court to raise any sort of monetary bond amount. However, because I would ask that she be supervised by community corrections. I think a GPS tether would be appropriate, given the additional concern of her potential fleeing the jurisdiction. So that would be my specific request, in addition to the standard terms and reporting via community corrections, the GPS tether, and no contact with Todd Scott. And then to comply with any sort of CPS orders that there might be regarding that case.
All right. Mr. Trush, comments?
Your Honor, I guess I would disagree with the prosecutor in the framing of this. The court has two things to consider when setting a bond. The first is appearance. The second is danger to the community. So first, to address appearance here, I don't think there's any reason to believe that she's a flight risk. She's lived in the Gaylord area for 14 plus years. She's employed and has 2 different jobs in the community. And quite frankly, maybe the strongest indicator of appearance is she has an ongoing CPS case. Her child is not in her care and custody, is in the care and custody of the department. And frankly, if she hopes and wants to regain custody and care of her child, there's only one way for her to do that, and that's to appear, right? I mean, quite frankly, I think in this case, we probably have a stronger argument for her appearing than in almost any other case. I mean, aside from her connections to the community, the other case in and of itself, I think almost assures that she's going to appear and participate in this. The second factor to look at here is, does she present as a danger to the community? Now, the court, I think, has to balance 2 things when looking at this. The first of which is obviously the seriousness of the offense here, and certainly not to belittle the allegations here. I mean, they're assaultive in nature, and there's at least alleged to be an injury that occurred because of it. So I would say that tends to cut on the side of more serious. The other piece of that is to look at what her prior history looks like. There's no prior assaultive history, no prior felonies. The only prior misdemeanor she has is a alcohol-related traffic offense almost a decade ago. I don't think that exactly presents as someone who's a danger to the community. I think it presents as someone who maybe didn't make the best choices that night, but the remainder of her life seems to suggest that she is making appropriate decisions. She reports to me that she also reported in her prior OWI offense that she appeared for every court date as instructed to. She has limited ability to post right now, but is employed, has 2 jobs and strong connections to the community. I would suggest to the court a low cash bond or even perhaps a personal recognizance bond would be appropriate given the circumstances.
All right, thank you. Ms. Burns, anything you wanted to say?
Not at this point in time. I think, I apologize. I don't remember your name, dear. One in the bottom. What's that?
It's Mr. Trush.
Mr. Trush, okay. No, I think you covered all the bases and explained everything really well. So that's about it. Thank you.
Where are you working?
I work at the Munson Hospital as a cook in the kitchen, and I work at Treetops Legendary's restaurant as a cook. I work every job, both jobs. I don't have days off between both jobs. If I'm not at the hospital, I'm at Treetops.
You know, I know a lot more about this case than I usually do when I do an arraignment because of the 2 I had. And without you having to react to this, you're a different person when there's not alcohol involved. There's no question involved in that. One of the bond orders on this is no consumption or possession of alcohol. There's also going to be regular testing. I mean, you're in a situation, and I agree with Mr. Trush on this, where obviously you want your children, particularly your younger child, back as quickly as possible. If you flee the state, you're basically giving that up. If you, people who have alcohol problems often slip up, but if you become abusive during that to people, that's also going to sidetrack, not completely eliminate, but sidetrack your ability to have contact with and eventual custody, particularly of your youngest child. And those are things I know are important to you and that you have under control. But I've also heard lots and lots and lots of stories. I don't know if they're true or not. I get lots of resisting and obstructing police officer charges. I rarely get one where there's a requirement of medical attention. And that concerns me. I have no doubt that there was alcohol involved in that. So a couple things. I just told Mr. Scott he's not to have any contact with you. I will tell you, you're not to have any contact with him. I know you live across the road from each other. No contact is no contact, period. Do you understand that?
Yes, sir. May I get any of my belongings that might be down there? My truck keys are down there.
You need to talk to him. You need, if you have a standby officer with you, that's fine. Don't do it on your own.
Yes, sir.
Don't do it. If you're back in jail, it's going to cause difficulties with you. As you know, this morning I issued an order saying you're not to have contact with your children unless it's supervised visitation, supervised by DHHS. I'm going to put the same requirement here.
Yes, sir.
So it's a double requirement, if you will, but just so you know that, I don't think that will be an issue. DHHS is, it's a reunification case. They want to get your child back with you, both children, but particularly the youngest one, they want to get back with you, but you have to get things in order.
Yes, sir.
You have an attorney in that case, you'll have an attorney in this case, there'll be two different individuals. What I have is the bond question. The prosecutor has made a request for a $10,000, 10% bond, which would require you to post $1,000. Mr. Trush is arguing for something less. Are you able to post $1,000?
No, I have $50 left to my name. I just got my first check from OMH. It took me a month to get actually hired on with their fingerprinting and physicals and all the tests that they required.
Just, hold on. Just answer my question. When is your next time that you work either job?
Well, currently based off of right now, I need to get to the doctors tomorrow and I need to get set up for concussion therapy. And at that point in time, I should be able to go back. They put me on leave for now due to the amount of trauma and damages that were caused by the two assaults Friday.
I recall those. So here's what I'm going to do. It's taking somewhat of a risk, but I will set your bond at a $500 10% bond, which requires you to post $50. I don't want you sitting in jail. I will tell you, if you consume alcohol, if you attempt to contact Mr. Scott, if you attempt to contact your children without being under the supervision of DHHS, you're going to be back in jail where I have control. Mr. Fortier, the prosecutor, raises a valid point. If you leave, and you maybe made that threat. Maybe you're just angry when you made it. It doesn't matter to me whether you made it. Mr. Truce is accurate. If you carry out your threat to leave the state, if you did say that in front of your child, that's a horrible thing to say. We all have done things that we regret in that regard. But my point is, don't leave. Your chance of getting your child back depends upon you cooperating with things.
That's the most important thing to me, sir, is my children.
And so, you need to talk to your attorney. You'll have a good attorney in this case. You've got an excellent attorney in your child protective case. Talk to her, get her advice on what you should do. She's very experienced in these things. So it's a low bond. It wouldn't be this low if there wasn't a child involved, because that does give me some extra assurance that you'll be present. But when authorities contact you, you can disagree with them. That is your right, but you cannot resist them. I'm not saying you did. I'm just saying you need to know that. And do not consume alcohol. You'll be monitored for that. If there's a positive test, you'll be in front of me or Judge Hessling, and they'll decide what to do. So you're getting a bit of a break to be out. Take advantage of it. Don't mess it up.
Thank you.
Do you have any questions?
on the note of doing a standby, if I'm capable of getting out tonight, is there somebody that could take me to that? Because I have no vehicle. I don't have my license or anything. It's all over at Mr. Scott's house.
I don't know the answer to that. I might call DHHS if I was you.
Okay.
But I don't know.
I gotta charge my phone.
Yeah, I don't know what they're gonna do. I don't know what they're gonna do. So you might decide you're better off not posting until tomorrow morning. So you have the full day to work with. It's cold out there today. But those are your decisions that you have to make. Okay. Counsel, anything further?
No objection.
No, Your Honor.
All right, we're all set. Thank you very much, officer.
Yeah. Thank you.
That yawn. That yawn at the end gets me every single time I see it. Oh my dear gosh. Oh my dear gosh. I don't even know what to say about that one. The low bond infuriates me. Everything about most everything there infuriates me, but what are you gonna do? It is for us to observe, not for us to really judge, right, chat? You know, they got the magistrates and the judges to do that, but oh my dear God, if it had been me, or if it had been any one of you out there, that lady would not have been so fortunate to have such a low bond to get out of jail. And today has just been, I told you, a series, just one bad decision after the other. They started off kind of mundane, started off with Judge Dad being very upset, like he has been all week. I got to tell you, Judge McNally is having a week, and I kind of feel bad for him. I hope people get a clue and start showing up to court and not being complete and utter disappointment for Judge Dad. But hey, we'll be watching and we'll see what happens tomorrow, the next day, and the next day. And we'll be doing the same thing. Same Wolf time, same Wolf channel, 8 p.m. Central Time, 9 p.m. Eastern Time. Hey, before you go, we do want to do this little thing we started doing here recently where we have all these supporters. Look at all these supporters. You murger. I can't. Jamurger. I don't know how to say it right. Thank you so much for your super chat. That's amazing. Thank you all for hanging out tonight. If you're a lurker, Rhonda's got a new Discord that she just put up. I've claimed it. I staked the flag and said, this is the official Lone Wolf Oosel Discord. Nobody else can say anything about it. But she named it something that, I have no control over that. But whatever she names it is awesome. It's like Rhonda's Court Friend Network or something. It's great. Go hang out. Discord's awesome. I love Discord. I have too many Discord servers that I'm a member of. Ladies and gentlemen, I'm your Lone Wolf Oosel, and I am beat. I've been putting flowers in pots and stuff all day today. I sowed some seeds for salad making. Mama's backyard. Got nice and dirty and a little bit too sweaty where I couldn't see and that type of stuff. Yeah, you know how it goes. Hey, hang out a little bit while longer. If you want some more court, there is more court to come. Lone Wolf Bot is live right now. I don't know who did that. I have it on good authority. The cat went in there, was like, not dealing with you people anymore. I'm gonna turn on my own court in the other room. He got Wolfbot to turn on the stream. So we're redirecting over to Wolfbot, in case you didn't know. That was my way to say all that. And if you're curious, you don't want to wait for the redirect. That's what the link looks like. You can click on that. For now, I'm your Lone Wolf Oosel. I am out. See you guys later. Oh yeah, I got the Ferris Bueller thing to do. Okay. In just a second. Good. Oh, look, it's a complete surprise. Nobody could have predicted that I was going to show up and make a Ferris Bueller reference and say, hey, look, I'd have nothing else. Go away. I'm such a disappointment. Judge Dad would be disappointed. Bueller. Bueller.